So we'll try to level up legally. Brief introduction, my name is Lukáš Mrázik, and I'll let Viliam introduce himself. We come from a law firm called Kinstellar. Kinstellar operates in 10 or 11 jurisdictions, from Czech Republic to Turkey, from Croatia to Uzbekistan, Kazakhstan, and in many of these countries we have a strong IP and tech team that try to focus also on the gaming aspect, because it is a very interesting and a quickly developing topic. So my main focus is data and cybersecurity, but also intellectual property and similar. And I'll let Vilo introduce.
So me as the second colleague, because in the introduction the Maros said that I'm the second colleague. So my name is Viliam, and I'm also the junior associate in Kinstellar, and my focus is on IP, IT, and also corporate law.
So the structure of the presentation, at the start we'll just try to set the scene, then the most part is legal points and a surprisingly a conclusion. So when it comes to the first part, what is generative AI and how it can be used, here I believe that you probably know more than I do. So I won't go into detail in defining what it is, the definitions change, but generally we understand that it is some algorithm or an AI model that generates new and unique content. Can cover anything from audio, images, text, and more. An important part is also that these models are trained on some pre-existing materials, which may on its own have some legal implications. An application in game development, this is really a question more for you, how you can or how you are already using it nowadays, and I believe that there should be enough time to cover some questions also at the end. So I'll be curious to hear how you are using it and whether you have any specific questions. But basically, what we see are two ways of how AI can be used now. First is using AI for some creative insight. So using Midjourney as a tool to brainstorm while developing concept art, or developing whole environments or specific characters using ChatGPT and similar tools, or incorporating some of the models directly into the game. So you can create environments that have dynamic capabilities, so the environment changes based on the user behavior, dynamically creating dialogue, so there wouldn't be any prescribed dialogue and set of responses, but something created on the spot, and also changing the whole gameplay based on the behavior of the user. So if you understand that the user is actually more skilled, you can adapt the game and make it more difficult, for example. And now to the legal side. So these are the three main aspects. The first one is IP. So who actually owns the work that is generated by these tools? Do traditional laws apply? And what about some possible patents or similar protection? Second side is the liability and accountability. And for that, we have also some new regulations that are coming our way, and we'll touch briefly on those, and data privacy and security.
So regarding the copyright challenges, we prepared two legal cases which are, let's say, really famous in copyright world. The first one is the monkey selfie copyright case. This refers to the series of copyright disputes regarding the selfies taken by monkeys with the equipment of wildlife photographer, and the issue was actually who is the owner of the copyright, if it is the monkeys or the wildlife photographer, and the U.S. Copyright Office ruled.
Just jump in quickly.
Okay.
The setting was basically that maybe you have heard about it, but the photographer spent some time with the macaque monkeys, became acquainted with them, then set a camera on the ground, and one monkey wanted to play with it and accidentally pushed the button to take a photo.
Yes. So the outcome of these legal disputes were that monkeys are not humans, so they are not able to be holders of the copyright. So at the end of the day, the wildlife photographer was the holder of the copyrights, despite the fact that he just placed that camera on the ground and the monkey took it and took a selfie. The second legal case is Zarya of the Dawn, what is the graphic novel contained with pictures generated by AI system called Midjourney. And the US Copyright Office ruled that this graphic novel as a whole cannot be protected by copyright due to the fact that the images within this graphic novel are generated by AI. So the copyright protection was granted only to the text of the novel and to the arrangement of the subsequent pictures within this novel. And the reason for this only limited protection was that the AI cannot be the holder of the copyright.
So just to summarize here, when you ask the question, who is the owner of Midjourney generated AI? First, as lawyers, we like to take examples from the past. We can take the monkey selfie case and actually see that there are a couple options: either the human, or the monkey, or nobody. With Midjourney, we know that there's not a real monkey in the game. There could be the AI, but AI again doesn't exist on its own. So there was the question that the laws try to look for the human, and sometimes the impact of the human is smaller. Do you have a question?
Yeah, regarding this area case. Okay, AI is not the holder, but somebody is owning the AI. So is the holder the owner of the AI or the user who created it?
Actually, we will get to that because we read the terms of use of Midjourney, and you will see actually who is the owner of the copyright then.
So when it comes to the copyright challenges, the first question is really whether the results, the pictures, are eligible for copyright. The first aspect is that there isn't any human. So the lawyers must actually somehow identify the human that would actually take the rights as the author. Second, what is protectable under copyright is always an independent work of creation. So even if you can find a human, you must find some creativity in the process. There, the question was whether a simple prompt would suffice. One could argue that Midjourney is just a tool like a paintbrush and colors, but the question that the US Copyright Office discussed was that actually the input from the human was not sufficient or was not a substantial part of the created picture. So there we run into an issue whether you do actually provide some of your creativity or you provide just a simple prompt saying a picture of a human by the lake. On the other hand, we could argue, even from past cases, that even the prompt is sufficient for copyright protection. In some cases, there was one case decided by the European Court of Justice where the court determined that even 11 words are protectable under copyright, or because in this case, the 11 words were taken from a article, and it was deemed that those 11 words, or any 11 words, could be the substantive part of the article. So even the 11 words were so important that they were covered under the protection of the whole article. But still, the traditional laws might not really be up to the task, and we see a number of cases coming up, mostly in the US, but in Europe as well. And it will be interesting to follow, because there are some cases are not necessarily AI related, but could have an impact on AI. I know that in Bulgaria, for example, there is a case with software develops works of art, but without any AI aspect. Now I'll hand over to Vilo to mention some of the ways some of the countries try to address this.
So, for example, the new framework in France is being prepared right now for the comprehensive AI protection. This framework consists of a couple of points which I am going to present. The first one is that actually when you would like to use some input which is already protected by copyright, you would need a consent of author of that input in order to be legally able to use it within AI systems. The second one is that that the authors who own the copyrights to the inputs would have also the copyrights for the AI-generated works. The third one is the new system for remuneration and taxation for the bigger financial transparency in royalties and these financial matters. And the last one is that you would need to, let's say, I think that this regulation is really author-oriented, and they are overprotecting the authors, because the question is that when you will put some input into the AI system, and the AI system basically generates something really new, what is really not similar to the input, the author would have the copyrights to that AI-generated work.
So in this case, what basically the legislation tries to cover is not the output of Midjourney, but the source materials from which Midjourney developed their model. So you have vast databases of existing works on which Midjourney was trained, and the question is whether the authors of those works should retain some rights in Midjourney's outcome, whether they should get some remuneration and so on. What is a question for the whole industry is that I think most of the large language models are actually trained on Wikipedia, on some of the published books, and there are basically very vast databases or collection of works, and some of the works have been scanned possibly illegally. So nobody really knows whether the Midjourney or whoever developed the end result based on some previous models, whether they have all the appropriate rights to all of the works. In some cases, it seems that they do not. And then the question is whether the whole model is infringing some of the rights. Second question, how would you actually even find out, and so on. Some of the studies that I have heard of was that they tried to, I think it's called prompt hacking or something like that. Using prompts, actually try to identify whether a specific picture was in the original source materials. So they had one specific picture of I think it was a lady standing in front of the library. And it was actually difficult to recreate the picture because Midjourney or another tool that they were using always tried to generate something. And so you had to be very specific in order to copy or get something that reminded of the original image, and even after hundreds of specifications of the prompt, it wasn't a direct copy because Midjourney or whoever was always editing some parts. So the question is that really, if it is, even if it's infringing source material, the result might not necessarily be infringing unless you want to create something infringing.
I have a question here. I also read about articles about actually doing more research. I found out they were using even ChatGPT, DALL-E, and so on, illegal sources. So apparently this is not one case, but it was well known by the developers, they still use. And if this happens, what will happen with the software itself? Are there already cases they are forced to remove these original artworks? What's happening after that? What is there? Are there punished for this?
There start to be cases. So, for example, one that I've heard of in the US again deals with Getty images. So you know, Getty images, you can get basically various types of images for your use in whatever marketing materials. But unless you pay for the picture, you have a watermark, Getty images. And it seems that some of the tools were trained on Getty images, and they learned that if you ask for a specific prompt, it must have a Getty images watermark. So it generates a new work, but it adds the Getty images. Yeah. So Getty images, of course, doesn't like it very much, and there is a lawsuit, but I'm not familiar. I don't think that they have come to a conclusion. But I think that we might not come to a conclusion very soon because it's not in the interest of Getty images nor of the provider of the AI tool to actually have a decision. It's easier to come to a settlement, maybe change some of the source data or the outputs and pay some fine. But
in principle, this is not correct. So they do not play fair. They do not play by then they, okay, we have great software, and nobody says that, I don't know, 25% is illegal. So
yeah, so the question is, I mean, it's interesting because then the fairness you could shift and say that Getty Images is not playing fair because they have published some of their painting, the pictures, and now DALL-E is actually developing and bringing a lot more creativity to the wider world, and therefore the fairness comes from the public benefit of the solution. But legally, I think they are wrong. Legally, I think if they use something to which they don't have rights, then it is an issue. Now, the question is also who's liable, but we'll cover that when we discuss the specific license terms. And now, again, Vilo will mention about something about the patents.
Another question is whether AI developed inventions could be patentable. So we have one interesting legal case regarding this issue, the Thaler comptroller case. That is the legal case regarding one inventor, Dr. Thaler, who developed the AI model, which was developed to an extent that there was no human intervention necessary, and actually that AI model was able to make its own inventions. And within patent applications, the AI model itself was designed as the inventor. And those two patent applications has been rejected by the UK Patent Office due to the fact that inventor has to be the natural person. It has to be the human, not the AI, not the AI model. So that's why.
So here again, we are running into the issue that the laws are human-centric, and we as lawyers need to find a human to actually grant the rights. Here, this case is now on the sitting with the Supreme Court in the UK. The counter-argument there is that if this is the case, then we should change the legislation because the UK will not benefit from the vast possibilities of AI-generated inventions, and it will basically be to the detriment of the industry.
And actually, I would add that the Tyler, as the developer of that AI model, argued that he developed that AI model, so he should own all the copyrights of the work which that AI model will generate. So that is another
Licensing. So here, actually, we've looked at some of the most used tools, and the key point here is that if you use the terms, if you use the tools, read the terms, because each of the terms are different, and you cannot assume that you actually will get the rights. And Vilo will mention some of the specific examples.
So we looked at Midjourney, ChatGPT, Scenario, and Emperor Music. The first one, Midjourney, I would say that these terms of use are, from a legal perspective, the best, because when you are using Midjourney and you are using the unpaid version, you are not the owner of the output. You just have to have the paid version in order to be the owner of the output generated by Midjourney. And actually, the interesting fact is that when you are the owner or the employee of the company with gross revenue more than $1 million, you have to have the two most expensive version of Midjourney in order to be the owner of the outputs. And actually, when you are using the unpaid version, the Midjourney assigns you only the Creative Commons license, what means that you can actually distribute these outputs, but you have to give the attribution to the author. So that means the author of the input, or also that this work has been generated by Midjourney. But on the other hand, you cannot use it for the commercial purposes. Another one is ChatGPT. Surprisingly, the terms of use of ChatGPT are quite clumsy, because there is only written that you are owner also the inputs and also the outputs. But there is a disclaimer that due to the fact that inputs can be similar, the outputs can be also similar, so there is a potential of copyright disputes. Would you like to add something?
Yeah, just continue.
Okay. The third one is the scenario. It is really similar to the ChatGPT. You are the owner of the inputs and also the outputs, but potential copyright disputes can be present. And the fourth one is the Emperor Music. Emperor Music has slight different business model compared to the first three AI systems. You just have to pay individual fee quote in order to be able to use this music within video games. So after paying this individual fee quote, that means that you just have to agree on that fee with Emperor in order to be able to use it within video games. And you will just get non-transferable, so you cannot transfer this license on a third person. And also this license is limited to the purposes which you will write within the order with Emperor.
So here, please do read the terms. You don't need to read everything, but usually you have the IP part and it's relatively straightforward. But it can help you to avoid a lot of headaches after you use some of the images and realize that actually you didn't pay $15 and you don't own all the rights, but the investor that will want to give you some money is asking this specific question. So second, I think one of the important points is that in the end, you are responsible for the way you are using it. So don't try to create something infringing, because the tool will actually not take any liability for that. So if if I tell Midjourney to make a copy of the Mona Lisa, it will create a copy of the Mona Lisa, but I could be infringing Leonardo da Vinci's author rights if he still had some, which he doesn't, but yeah. So now, what are the recommendations? So first of all, it's good to document ownership. This is something that all lawyers will tell you every time, but that's the boring bit. But it's helpful to actually understand who developed what, so you can assign the copyright. So in case anybody asks, you can actually tell them that this person developed that. And the same applies with AI systems, so it's helpful to understand how you came to the end result. Another recommendation is to incorporate the tools into the process, but not replace the creative process. So if you actually just take, if you use a Midjourney picture based on a simple prompt, then you actually might not have added the relevant creative input for your ownership of the copyright to actually begin. But it's important to use these tools within your process. So tailor the prompts, make some efforts to actually develop the specific picture. Once you have it, you can add it in Photoshop and so on. Change it, make some important changes from your perspective. This all will change the perspective that you didn't just take something that wasn't yours, even though you could have a license or so on, but you are incorporating it into your wider process, and you are the owner of the whole process. That might be also important for if you're using GitHub Copilot or something for developing code. If you copy it, it might not be yours, but you can, if you slightly change it or incorporate it into the wider picture, you are the author. License permissions understand your rights and limits to the tools. When it comes to your ownership, it's still a developing field. So, for example, in the Zarya of the Dawn case, the author actually did a lot of effort in changing the prompts, and did also change the pictures in Photoshop and rearrange those. But the US Copyright Office still protected only her specific inputs, not the outputs of Midjourney. So it's still unclear. The US Copyright Office does not have the authority to set the law. In the US, it's the courts. This hasn't gone to the courts yet, so the courts might decide otherwise. But it is one way some clever lawyers look at this point. To your question?
I have a practical question. So I can take her work and I can reproduce it and sell it without her consent somehow, because she is not owner of everything. Or I cannot, because she is at least owner of part of it.
So this brings us to the monkey selfie case and Zarya of the Dawn. So with the monkey selfie case, there was actually the question, because if the picture was taken by the monkey and not by the human, and monkeys cannot have copyright, then copyright did not start to exist. So anybody can use it. Wikipedia posted it on the website, and the human that set the scene sued Wikipedia for remuneration. So in this case, you could take it and without her license, but the devil is in the detail. So I'm not sure what tools she was using. Maybe she did recreate it and added a lot of her input, and maybe some of the US judges would actually lean her ways. So theoretically you could, as a lawyer, I would not advise it to do it.
Another question. There was a case game on the Steam. The guy was using some generative pictures inside some, and the Steam take down his game because there was accusation from somewhere, I don't know, maybe from some public, from some user. So they put the game down. He's not able to sell it. Even he did like 90% of the game, and still there is like 10% of generated content inside. And for Steam, is it like a kind of problem which may result in can this guy sue Steam that as a platform is not providing him fair conditions to compete on the market or not?
That would
He's losing money apparently, and still there's a lot of work inside.
I don't know, because that would depend on the terms of use of Steam. So basically, Steam can decide what to include in the terms, but
from my experience, for example, Steam is quite they take the safe path. It doesn't matter 1%. Yeah, so we had the situation where, for example, developers sued the publisher because they were not paid. And it was not about copyrights like AI generated, so it was internal discussion, and Steam took the game off. So guys, clear this out, and if it's clear, then you put it back, because you don't want to be. So Steam is quite strict there. If there was some uncertainty, who has the rights, whatever.
I think there was people are argumentation that he was using Midjourney, and the Steam claimed that Midjourney in EULA is not giving the full rights. There is some paragraph speaking something which is ambivalent, maybe.
maybe if he was using the free version of Midjourney, he would have an issue. And so he would not hold the rights. Therefore, Steam could actually, or could block it if it's in their terms, because it's unclear and yeah.
Let's say I have the paid version and I'm the owner of the output. You mentioned the framework in Paris, but how is it like in our country? So let's say I do the input like make me a logo for a game in style similar of Warcraft 3 or something. Do I have to ask Blizzard? Like, I understood it, like the way you explained it in the...
Yeah, actually, when the act would be passed, as I have said, because it is only the draft act, that doesn't mean that it will pass. This act will pass as a whole. There will be some changes, amendments, and so on. But yeah, when you would, for example, when you would put the logo of World of Warcraft to the Midjourney, and I assume that they have copyrighted it, the Blizzard would be actually the owner of your outcome.
Actually, I got personal experience. I put some picture, making something similar like Warcraft. It will not generate anything. The World of Warcraft is bought now.
And I think the tools are also developing, so they are putting their limits, trying to avoid obvious attempts for copyright or other infringements. But people are creative, so you can create still some infringing rights. But yeah, it's consider it just as a tool. If you use your paintbrush and paper and painted something that is very similar to the Warcraft 3 logo, then you could have an issue because you could be copying it. The question there would be whether it's an independent creation, so you developed it independently, or whether you copied a substantive or a substantial part of an existing work that is protected by another person. Data privacy, the best topic, GDPR and similar. I'm sure that all of you love it. Of course, privacy is also relevant in when it comes to generative AI. The examples how AI can be used are vast. You can profile players. You can basically use data mining, tailor the games either by analyzing the behavior of the individual to adapting it, or tailoring the sales and targeting specific sales to the individual based on your behavioral analytics. Of course, if you have some in-app purchases, then it's much more efficient to tailor those to the individual and create something specific because you know what the person might actually want. If you have some chat tools, even if the person is chatting with a AI character, it could still be considered, the content of the communication could still be considered as personal data, especially if they disclose something personal. But this could include any other examples, and yeah, just the sky or the creativity is the limit. But we have seen that actually data protection has already played some important role in delaying the rolling out of some of the tools. Italy, for example, banned ChatGPT in March, which was the first country to do so. The question there was that the authority did not see a valid legal basis for the source data. So, for example, at that time, if you included who is Lukáš Mrázik, ChatGPT actually gave you some information that was publicly available online, and the authority thought that OpenAI did not have obtained my consent, neither had other legal basis, and legitimate interest wasn't enough. Second, there was a claim that ChatGPT did not properly inform the individuals of using their data. Since then, ChatGPT has changed their privacy notice, implemented some tools. So for now, if you type in who is Lukáš Mrázik, it will say, I can't provide personal data, or I don't know, or something like that. One case that I've heard of, I'm not sure in which EU country it was, but at one point, when ChatGPT did provide some information about Lukáš Mrázik, of course, it's not 100% correct, and it can hallucinate. So when I tried it with my colleague, the profile was actually perfect or looked perfect, but the result was that that person studied law at Communist University and had obtained a master's degree from Edinburgh University, which was not true. So it fitted perfectly into the profile of a lawyer, but it just wasn't true. From the GDPR perspective, this would be inaccurate personal data, and the individual would have some rights to correct it and so on, which in ChatGPT doesn't actually make sense to correct it because it was just an output from a chat. But it could have an impact in other cases if you use it to evaluate individuals based on publicly available data and so on. The right to be forgotten. Again, similar setting. If ChatGPT learned something, or if the model was used on data which included my personal data, can I tell ChatGPT to delete the data? Even if they comply with the underlying data sources, which I'm not sure if it's technically feasible, what about the actual model, whether there's anything data within, or how the algorithm was developed and so on. So we would run into some technical difficulties. Cross-border data transfers, that's an issue, but especially if the servers are in the US and there's international data flows. From the perspective of EU data protection laws, you must write some agreements and so on. So there are some additional difficulties. And there are also security concerns. So these generative tools are actually very good tools for hackers. It can increase or expand their capabilities to actually perform the hacking attacks, but also can be a source of or a target of the attack. So ChatGPT, for example, suffered a data breach, and I think the hackers obtained access also to the content of the communications. So it's not perfect as well. Recommendation here, just try to think about it with a common sense, whether there's any risk exposure, if you use any personal data, if you evaluate any individuals, if you make decisions that could impact the individual. Those are the right questions to ask. And if you feel that there could be a risk, do a balancing test or data protection impact assessment or something that you can read online or ask a lawyer to do. I think now Vilo will mention about the AI Act, but I think we can also just make it a little bit shorter so we have a discussion.
Yeah. Okay. So AI Act is the first comprehensive act which should be effective in 2024. This AI Act should be directly applicable across every EU member state, and this act will be relevant for all the players, so providers, importers, distributors, and so on. And actually, the AI systems should be divided into 4 categories. The first one is the AI systems which pose unacceptable risk to the users. So that means, for example, social scoring or influencing the human nature to the extent which is just unacceptable, and these AI systems will be banned. The second category are the AI systems posing the high risk. That here belongs, for example, healthcare systems, also law firms, and these AI systems will have to be entered into EU dedicated database and pre-assessed in order to be able to use for the users within the European Union. The third category is the limited risk. To this category will belong also the generative AI, because within generative AI the images, videos, audio, and video is being used. So within this category, as the provider or the developer of generative AI, you will have to inform the users that hey, you are using the AI and this is not the reality, and the user will have to have the opportunity to stop using this AI system. And the low and minimal risk, there are basically no obligations, but there is a strong recommendation of writing the codes of conduct for these AI systems.
So what is relevant for you is that, especially if you use some generative AI in your visuals, there may be some transparency obligations. So the idea of the parliament, the legislature, was that if you have some deepfake videos, the people watching those should actually receive a notice or something that it's not the reality, but it was just a generated video, fake or not a fake, to actually provide control to individuals to understand what they are looking at. Within games, I'm not sure how these transparency obligation would actually be implemented, but it could be something to consider. But this is still, the wording are still of the AI Act are still negotiated. We expect that they will be adopted early next year, but there's a 2-year period for the implementation, so still enough time. Other regulatory considerations are, similarly to the AI Act, the EU is also preparing a AI liability directive. The timeline could be more or less similar, but this is basically very simple piece of legislation. The logic here is that if you are hit by an autonomous car and will want to sue for damages the manufacturer, you will, as an individual, you will never be able to obtain information necessary to evidence to provide evidence to the court that it was the fault of the AI and not somebody else. So what the AI liability tries to do is that if you sue Tesla, for example, for damages and not the people sitting in the car, because Tesla will likely have more money than the individual sitting inside. If you sue them, then Tesla will have to provide you all relevant information supporting the case, or relevant information for the case. So information that supports you, but also information that supports Tesla. So the goal is to balance the imbalance of power. And NIS2 directive, this could be relevant for some gaming studios. So basically NIS2 imposes certain cybersecurity obligations, but it's relevant only for companies that are not SMEs, so not small, medium enterprises. So I think if your revenue is less than 55 million, or you have less than 250 employees, then it should not apply to you. If it applies, you will have to have some appropriate cybersecurity procedures, controls, and so on in place. Conclusion. So what are, in our opinion, the key points to remember? First, read the license if you use the tool. The wording can be very straightforward and short, so you don't need to read everything, but it can guide you to whether actually invest those $15 for a monthly subscription or not. Try to incorporate AI into your process, not to replace your process as a whole, because there you can develop your own IP and you will resolve some of the potential issues on who is the author or who owns what. Document who's done what, so understand or have some evidence of how you came to the conclusion. If you, for example, ask to create a logo similar to Warcraft and document it, then it would go against you. But it's much better if you document that actually you develop the logo individually based on these prompts that have nothing to do and have not had Warcraft in mind. So documenting can help even in this case. Consider privacy risk if you have personal data, behavior analytics, and so on. Think about it, and don't forget about security. But with security, it might be something not so important at this stage, but if you do have personal data about a higher number of individuals, then you'll become a much more interesting target. Or even if you have some chat rooms or ways to upload documents, there are some games that on which confidential materials of the US Army were published. So yeah, it could present its own risks. And don't forget, there's more to come, and this is a developing field.
I just want for the slide before, I just wanted to share with you some ideas. So if you are doing work for hire, so you are the developer, you are for a publisher, discuss with the publisher if you, in your part of your work, you use AI, because then depends from deal to deal, they might not agree. So I suggest before you have troubles later, okay, if you do self-publishing, it's your thing, but usually a lot of people do work or hire or whatever, clear in advance with the...
That's a good point, because, and it might not only be the publisher, but the publisher is a very good point, but other investors might actually want to invest into your IP. So the first question would be whether you have the IP.
Once I was not from beginning, but one thing that people don't think about AI, it's already used is from the translations, and Google Translate, and was actually one of the first AI widely used, and there are a lot of deals where they specifically you are asked to not use on AI translation tools, specific for the situation where the text of the project contains license terms. And we know for a case, for example, it was a translation of the language from a title based on a movie, I think. One of the big Hollywood movies, it was still top secret. And the translators use automatic translation text. And they did some correction, but this correction was taken over by the AI, and the translation appeared in the AI database, and the license holder found out. And it was not pleasant for the translators.
Yeah, that's also a very good point, because if you upload any images, the tools are usually designed that what you upload they will reuse to train their model and so on. So it would be also interesting, and us lawyers are also advised, if we use the translation tools or ChatGPT and so on, not to actually include a specific question that would relate to a specific client, because that would be in breach of the attorney-client privilege, for example. And the same for you, if you upload some valuable IP into Midjourney or whatever, there could be some additional issues with that.
Actually, by uploading to the most of these AI systems, you are automatically granting the license to the developer of that AI system. So beware of that.
So you mentioned that you are the owner of the input and also the output when using ChatGPT. So if I write a novel with ChatGPT and another person writes a novel with ChatGPT, and they're very similar, and one sues the other, then what happens?
So there is the disclaimer in the terms of use that the inputs can be similar, and the potential copyright disputes are here. But from our observation, when we read the terms of use, the most of the AI developers don't know what to do with the copyrights yet, and it is really visible from our side that there are many loopholes to fill. So yeah.
But here, I think the answer is that no matter the result of the dispute between the two authors, nobody could sue OpenAI.
Yeah.
So OpenAI provides the disclaimer and will not be liable, most probably. But the dispute could still be between the two authors, irrelevant of how whether they used AI. So the court would look whether there was anything infringing. So if the second author developed something completely independently, likely there would be no infringement, because under copyright law, you can develop the same thing independently. If you take the picture of this building from the same position, and somebody takes the same picture 1 year after you are not infringing each other copyrights, but you've developed independently the same thing. But if you want to recreate something that you know of, you want to intentionally copy it or take some important parts, you include the main character Harry Potter there, that would be possibly infringing.
Like, how do I prevent my work from being used by the database? Because I seem to have like no recourse for now. It's just like, yeah, like I can't protect my artwork right now because if it's on the internet, it's going to get spoofed by any algorithm. And besides like poisoning the image through like this glaze algorithms or Nightshade recently, I can't really do anything about that. Like, what legal framework protects me from my image being used in any algorithm, like any generative model?
So the simple answer is not to post anything online, but that's not realistic. Second is if you have appropriate access controls, if you're posting something on Facebook, then you can restrict it to your friends. But again, that might not be helpful. My understanding is that the models always use some specific source data. There are large data models from the books. Wikipedia is used. So if you want to protect a specific picture, don't post it on Wikipedia, because there I think you grant a Creative Commons license. Then I think there were some specific other sources, but so you can try to avoid those sources that would likely be reused. But
maybe you can read the terms of use, and maybe by some AI system there will be the clause that when you will upload that input there, you are still the owner of the input, and you just not granting any license to that AI model.
I don't know the response, but for example, you can also, if you have a website and you don't want it to be crawled, you can add basically a specific restriction on the crawling. So maybe there's a way to use the metadata.
But I guess like get the image has that in terms of use, but the image in the database anyway. So you kind of prove they disregard those safeguards.
So
you wouldn't have like get the image in the database if they respect to that.
like a specific example for concept artists, for example, in games is most of these people post their portfolios on a site called ArtStation that is data mined and used for training AI models, while some of those companies don't really disclose the sources of their training data. But a lot of them actually use ArtStation, where most of these kind of people post, for example, their art.
For example, by this new AI Act, the AI systems which would belong to the limited category would have to disclose their training data.
Yeah, but I think none of the answers are solving the issue.
Yeah.
But
The image is already done. Actually, I know, for example, if you post your portfolio on Debian or something like this, I think the terms it's mentioned that the rights belong to the author. So it's clear something, but they don't care if they just copy the image from Getty Image. And Getty Image is quite huge, but artists, and they make a lot of money.
Yeah.
So even if they didn't were not able to protect the images.
maybe one point to consider is also that what damage would you actually receive or have just by the fact that your picture was included into the database. Maybe there would not be any damage, but if somebody does intentionally want to recreate that image, it would be helpful for you to understand that you posted the image on this side and it was crawled and used, and then you can develop a claim against that specific person infringing your rights.